Hello, everyone. Welcome to the Lower Speeds live class. Let's go ahead and get started. Mute everybody. Okay, let's start off with some common words. Here we go. Poison, seat, summer, work, polish, secretary, support, wound, porter, selection, surprise, writing, position, self, year, swim, able, free, public, delicate, possible, acid, frequent, quick, dependent, present, angry, full, quiet, private, automatic, future, ready, dirty, probable, awake, general, red, dry, sudden, bad, good, responsible, early, sweet, tall, elastic, regular, gray, beautiful, bent, great, right, electric, thick, thin, equal, rough, green, bitter, black, hanging, round, false, tight, fat, tired, sad, happy, blue, boiling, hard, safe, feeble, true, violent, female, same, healthy, bright, broken, high, second, fertile, waiting, first, warm, secret, hollow, brown, certain, ill, separate, fixed, wet, flat, white, serious, important, cheap, chemical, kind, sharp, foolish, wide, mixed, wise, last, chief, clean, late, shut, narrow, wrong, natural, simple, left, clear, yellow, slow, necessary, cold, like, slow, young, new, living, small, common, long, smooth, normal, complete, old, loose, complex, soft, open, solid, loud, conscious, special, opposite, low, cruel, male, parallel, cut, sticky, married, past, dark, physical, stiff, straight, material, dead, strange, political, dear, medical, poor, strong, military, deep. All right. Let's do some names and addresses. Here we go. Ready? Juanita M. Castillo, ILLO, Hardy County High School, 200 South Florida Avenue, Tampa, Florida, 34873. David L. Kaplinski, KOPLINSKI, P.O. Box 2000, South Lake Tahoe, California, 95705. Barb A. Hansen, HANSAN, Route 2, Box 86A, Hinckley, Minnesota, 55637. Mr. Donald R. Lawrence, LAWRENCE, 4029 Vista Street, Philadelphia, Pennsylvania, 19136. Geneva L. Golson, GHOLSON, 40 North Avenue, Newark, Ohio, 43050. Little Falls Community High School, 1001 Fifth Avenue, Southeast, Little Falls, Minnesota, 56345. Karen R. Anaginst, ANAGNOST, 221 Steuben Street, Montour Falls, New York, 14865. Counseling Office. Attention, Ms. Linda B. Parker, PARKER, 1110 North Hillcrest Street, Greenville, Michigan, 48938. Dory L. Spiller, SPILLER, Route 2, Box 425, Park Falls, Wisconsin, 54502. All right. Let's move into consonant compounds. This is a continuation from yesterday. We're going to focus on the initial consonants, SPR. Here we go. To sprunt and sprint, you must be spry. Springwood is in spruce, not sprinklers and sprockets. Spread the spruce and sprig the sprouts. He stepped spryly instead of sprinting in the spring. A springboard is not for springbok and spring chickens. Spring sprung when she spread sprigs. Sprat loons are caught by springy spratters. She sprained her ankle sprawling. The spray from the skunks spread. Under the spreading chestnut tree, the sprightly sprinter sped. A springboard is like a sprite. The sprocket was spruced up. A young, proud sprout is sprightly. Your sprocket is sprung. Old men are sprier. The springy sprite was sprightly. In the spring we have sprinklers. He was only a sprout, but he could sprint. Hope springs eternal. A springboard is springy. All right. do some common, or these are just common phrases in short sentences. Here we go. My own father, you must be right. Read every story. Stay a while. Will it last? Next time. Light the fire. For example, a group of friends under the earth, both the children, the big city. Read the paper. A good thought. Until the end. Is it really true? Almost enough. Near the sea. Read your book. An important idea. Too soon. A group of people. The long list. It began to grow. Next to me. I miss you. I took the car. Above the clouds. Without a care. My feet hurt. All right. Let's do some Tangle Tamers. Here we go. And these are actually going to be Tangle Tamers that are in legal phrases. Here we go. The jury is satisfied. Establish such proof. Verdict of acquittal. Fair and just verdict. Guilty of negligence. Based solely upon. Burden to establish. Reasonable, careful person. In this regard. Instructions of law. Common law negligence. Direct, unbroken sequence. Duties of citizenship. Rule on admissibility. Admission of fact. Physical evidence. Arguments of counsel. Contributorily negligent. Reaching your verdict. Exclude from consideration. Innocent until proven guilty. Benefit of the doubt. Performance of your duty. More likely so than not so. All right. Let's do some medical words. Here we go. Ready? Treatment. IV. Splatter. Patient. Alzheimer's. Vaginal. Visceral. Gastric. Testosterone. Subluxation. Atrophy. Hemorrhage. Orthodontia. Reproductive. Neurologist. Melanoma. Obstetrician. Sublingual. Inflammation. prognosis, hepatitis, disease, synarthrosis, cerebrum, cervical, insomnia, angiogram, plantar, cardiac, myelogram, cystocele, retrograde, orifice, thyroid, leukocyte, hemorrhage, proctologist, ischemia, hypodermic, pectoral, hypoglossal, histology, articulate, hepatitis, diaphragm, remission, intractable, codeine, prednisone, standardized, metabolism, subluxation, transverse, clinical, dizziness, cellulitis. All right. One last drill and we're moving into literary. Okay. Now this drill is going to focus on inform, information, forward, and forward. I'm going to start off with some phrases and then move into the sentences. Here we go. This information, inform her. The information, inform us. For me, inform me. Any information, inform them. That information, inform you. Your information, all information, inform him. For him, informed him. For that, her forward it, informing us. Forward that, his forward, informing him, informed us. For them, my forward them, informing them. For this, informed her. Here are the sentences. The court has been informed. Use your information. For now, it is fine. Send us the information. A forward would be good. I am informing you. Please do it for me. Is this for Grace? I am informing my client. Where is the information? Have you forwarded it yet? Be sure to keep informed. Ask for information. Throw a forward pass. We were so informed. Inform us promptly. Please inform us. Inform me today. Who is informing you? We informed the judge. Get the information. The information isn't right. I have been informed of it. The information is for me. Were you informed? Buy me a new Ford. It's all for you. Make an informed decision. The paper informs you. Did you forward that? I can't inform them. Who has the information? Forward the information. Forward my mail. Sell your old Ford. I was not informed. All right. Let's move into some literary. We're going to start off with some land description. Do a little bit of that and then go into jury. Actually, this is jury instructions. Okay. All right, here we go. This is the area to be detached from the North Central Fire Protection District and the Kings River Conservation District and annexed to the city of Fresno, consisting of a portion of section 23 and 26, and both said sections being in Township 13 South, Range 19 East, Mount Diablo Base and Meriden, and the beginning at the northwest corner of the southwest quarter of the southeast quarter of section 23, Township 13 South, Range 19 East, Mount Diablo Base and Meridian, as said section is shown on the United States government township plats, being also a point of the existing city limits of the said city Fresno, thence easterly along the north city limits of city of Fresno, line of the southwest quarter of the southeast quarter of said section, then being also along the existing city limits of said city to a point 137.49 feet west of the northeast corner of the west half of the southwest quarter of the southeast quarter of said section, thence southerly along a line parallel with and 139.69 feet west of the east line of the west half of the southwest quarter of the southeast quarter of said section, being also along the existing city limits of said city, a distance of 158.41 feet, thence easterly along a line parallel with the western half of the southwest quarter of the northeast quarter of said section, being also along the existing city limits of said city, a distance of 137.49 feet to the intersection with the east line of the said section, thence southerly along the east line of the west half of the southwest quarter of the southeast quarter of said section. All right, we're going to stop there. There is more, but we will finish that one next week. Okay, all right. All right, so let's do some closing arguments. Actually, it's jury instructions. With this same case that we've been working on for a while now, okay? All right, here we go. This is a continuation. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an object or objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. You are not required to, but you may take notes during the trial, except during the opening statements and closing arguments. The court will provide you with materials. In taking notes, you must be careful that it does not distract you from carefully listening to and observing the witnesses. You may rely on your notes to refresh your memory during deliberations. Otherwise, keep them confidential. Your notes will be collected by the jury bailiff after each day's session and kept in a secure place until the next day of trial. After the trial, the notes will be collected and destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. You may ask to have specific portions of the testimony read to you. You should pay careful attention to all of the testimony because you must rely primarily on your memory of the evidence and testimony introduced during the trial. To assist you in evaluating the evidence, I will now read to you portions of the specific jury instructions for the offenses with which the defendant is charged. I will read them to you in their entirety at the close of the evidence. Count one of the information charges the defendant with first-degree intentional homicide as party to a crime. To the crime. Section 939.05 of the Wisconsin Criminal Code provide that whoever's concerned in the commission of a crime is a party to that crime and may be convicted of that crime, although that person did not directly commit it. The state contends that the defendant was concerned in the commission of the crime of first-degree intentional homicide by either directly committing it or by intentionally aiding and abetting the person who directly committed it. If a person intentionally aids and abets the commission of a crime, then that person is guilty of the crime, as well as the person who directly committed it. A person intentionally aids and abets the commission of a crime when acting with knowledge or belief that another person is committing or intends to commit a crime. He knowingly either assists the person who commits the crime or is ready and willing to assist, and the person who commits the crime knows of the willingness to assist. To intentionally aid and abet the crime of first-degree intentional homicide, the defendant must know that another person is committing or intends to commit the crime of first-degree intentional homicide and have the person or purpose to assist the commission of that crime. Before you may find the defendant guilty of first-degree intentional homicide as a party to the crime, the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant directly committed the crime of first-degree intentional homicide or intentionally aided and abetted the commission of that crime. All 12 jurors do not have to agree on whether the defendant directly committed the crime of first-degree intentional homicide or aided and abetted the commission of the crime. However, each juror must be convinced beyond a reasonable doubt that the defendant was concerned in the commission of the crime in one of those ways. First, degree intentional homicide, as defined in 940.01 of the Criminal Code, who causes the death of another human being with the intent to kill that person or another. Before you may find the person, the defendant, guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Number one, that Brian Dorsey caused the death of Tracy Hall or aided and abetted another in causing the death of Tracy Hall. Causing means that the defendant's acts were a substantial factor in producing the death. Number 2, Brian Dorsey acted with the intent to kill Tracy Hall, whether he did so directly or aided and abetted another. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. And there is more, but we're going to stop there. Finish the rest of that next week. Again, I kind of treated that as literary and jury charge because it's, pretty much at the beginning of the trial. So he's using a lot of the just your everyday words. So I kind of combined that, and that's why I read it a little bit, a longer period of time so that I could combine that with the literary and jury charge. Okay. That's important that you get that sustained dictation so that you're, you can write for longer periods of time. Okay. All right. That's called endurance training. All right, let's get on with some Q&A. Looks like defense is questioning. This is a continuation of what we've been working on. And then I'm going to switch over to another transcript, okay? All right, here we go. Ready? Did you ever look at a copy of the police report that was made? And I didn't really explain what I'm doing. I'm going to start at 16, work my way to 100. Okay. Yes. When did you look at that? 2017, I believe. What occasion did you look? What occasioned you looking at the police report? They had a lawsuit. The driver had a lawsuit against us, which was dismissed by the courts. Do you know where the suit was? Riverside County. Did you ever become aware as to why it was dismissed? No, they just told us it was dismissed. Were you served with a copy of the summons and complaint? Yes. Do you know if it was municipal or superior court? Municipal. Was either of your parents served with a copy of the summons and complaint? My mother was. What, if anything, did you do with your copy of the summons and complaint? Well, actually, I gave it to my mom and she filed them. Do you know what, if anything, she did with them? She kept it in a file cabinet. I think it's still there too. Do you know if she contacted anybody about them? No. While the police were inspecting your vehicle, was either the driver or her husband around either of the vehicles? No, they were inside the house. From the time that the police arrived, did you have any other contact with any of the driver or her husband, or after or before the police left? After they left or before they arrived? What do you mean? Okay, well, I have the impression that as the police were arriving, let's strike that. When the police arrived, did they make contact with anybody at the residence? Yes, they did. They went into the garage and talked to somebody. I don't know who. Did you see them talking to either the husband or the driver of the other vehicle? I believe it was her husband, because she never came out of the house since she went in. Did the police officers go in? Yes, they did. Did any of the paramedic personnel or the fire personnel go inside the house? Yes. Did you see inside the house after? Yes. Yes, I did. Did you go inside the house? Yes, I did. What, if anything, did you witness while you were inside the house? She was laying on her couch, complaining about headaches. At the time that you observed this, was there anyone else in the room? Her husband, the police officers, and the paramedics. When you say she was complaining about her headaches, can you give me a summary of what she said as opposed to describing what she said? I couldn't understand her. She wasn't speaking English. How do you know she was complaining of headaches? She had her hand on her head like it was painful. What portion of her head? The front part. Did she speak English at any time that you were there? When I was there, no. Okay, let's switch transcripts. I got up to 100 there. This one's a little bit more difficult. This is a court case, so we will have the court come in. I'm going to start right at 100, okay? Okay. What's the name of your case? Netter. N-E-T-T-E-R. Netter. Okay. We can take it up. That was scheduled for a settlement conference today. Settlement conference. And you haven't been able to accomplish much, I take it? Unfortunately, no, Your Honor. William Anderson, on behalf of the petitioner, who is present. They're in mediation right now on those issues. I'm pretty confident that we will resolve it, but I've been kind of confident all along that we wouldn't make it this far. And here we are. What issues? I guess the issue of the loan is a big issue. That's a big issue. That's about $120,000 issue right there. We would hope that we would be able to resolve this, but it isn't going to happen. We'd hoped that the other side wouldn't make us put through what we know or have to prove documentarily what we feel that they know happened. But it doesn't look like or appear that this is going to occur. We're going to need some more time. That's now set for trial. It's set approximately 10 days away, I believe. Trial is set for August 26th. August 26th, what's your pleasure? I would first of all object to any kind of a continuance of trial at this time, mainly because my client has had to go to a great deal of expense to be here this entire day. We have fully prepared. We've got our statement of issues. We've got our statements, our income and expense statements. We have our assets and debt statements. Did you deny that there was a loan in your response? Yes, we did deny that in our response. Again, we did not set this matter. What will a continuance avail you? Well, Your Honor, I'm confident that we can come up with a copy of the check from Sophie Netter, that's my client's mother, to the parties. It's indicated from my client that loan is written out on that check. That would be one bit of documentary evidence. Also, I believe that we can locate, I'm sure, my client is confident that the respondent has the canceled check showing that the parties paid $20,000 to Mrs. Sophie Netter as an interest payment, interest-only payment, when they refinanced or sold the original house that they bought using that money and purchased the house that they have now out in Moreno Valley. When was that done? That was done in 2008 or 2009, I believe. My client denies that there was any such payment. My client left the home in October of 2015, and she left with less than $1,000 worth of property. There still remains in the home approximately $117,000 to $118,000. Your Honor, we're getting off again here. Now, of goods and equipment. She didn't get any papers. She didn't get checking account materials. She doesn't know what the loan balances were. She has nothing. So she is at a loss where this claim that she has some kind of a loan is coming from. We can trace back through. My client says that there were several accounts that they had in transition from moving from Garden Grove, I believe, to here. So we're going to have to check through. How much time do you think you'll need? We need about a week. All right, let's do some read back. All right, so I read that whole thing at 100. All right, here we go. This is going to be plaintiff questioning. I'm going to read the first one at 100, then at 80, and then at 60, okay? Here we go. Were you and your husband conversing as you proceeded from the dentist office to the car? I don't remember that. And when you reached the car, did your husband help you in the car? Or what did you do? No, he didn't. I just got in the car. Did you get in the car on the passenger side of the car? Yes. You entered from the curb side of the car? Yes. Did you notice any traffic proceeding north on Lincoln Boulevard at the time? I didn't notice. Did you notice any traffic of any kind? Well, there was traffic. Do you know which way it was going, or were you conscious of it? The traffic was going north. And what did your husband do upon reaching the car? He started around to get in the car on the other side. Did he go in front of the car or in back of the car? He went in front of the car. What is your husband's first name? Ian. Did you observe your husband going in front of the car, or were you entering the car at the time? I wasn't paying attention to him. And when did you know that there had been an accident? I heard it hit. What did you hear? I just heard a thump. Where were you at the time? In the car. You were already in the car seated? Right. Had you closed the door? Yes. All right, so let's do that again at 80 words per minute. Here we go. Were you and your husband conversing as you proceeded from the dentist office to the car? I don't remember that. And when you reached your car, did your husband help you in the car? Or what did you do? No, he didn't. I just got in the car. Did you get in the car on the passenger side of the car? Yes. You entered from the curb side of the car? Yes. Did you notice any traffic proceeding north on Lincoln Boulevard at the time? I didn't notice. Did you notice any traffic of any kind? Well, there was traffic. Do you know which way it was going? Or were you conscious of it? The traffic was going north. And what did your husband do upon reaching the car? He started around to get in the car on the other side. Did he go in front of the car or in back of the car? He went in front of the car. What is your husband's first name? Ian. Did you observe your husband going in, or were you entering the car at the time? I wasn't paying attention to him. And when did you know that there had been an accident? I heard it hit. What did you hear? I just heard a thump. Where were you at the time? In the car. You were already in the car seated? Right. Had you closed the door? Yes. All right, let's do it one last time at 60. Here we go. Were you and your husband conversing as you proceeded from the dentist office to the car? I don't remember that. And when you reached your car, did your husband help you in the car? Or what did you do? No, he didn't. I just got in the car. Did you get in the car on the passenger side of the car? Yes. You entered from the curb side of the car? Yes. Did you notice any traffic proceeding north on Lincoln Boulevard at the time? I didn't notice. Did you notice any traffic of any kind? Well, there was traffic. Do you know which way it was going? Or were you conscious of it? The traffic was going north. And what did your husband do upon reaching the car? He started around to get in the car on the other side. Did he go in front of the car or in back of the car? He went in front of the car. What is your husband's first name? Ian. Did you observe your husband going in front of the car, or were you entering the car at the time? I wasn't paying attention to him. And when did you know that there had been an accident? I heard it hit. What did you hear? I just heard a thump. Where were you at the time? In the car. You were already in the car seated? Right. Had you closed the door? Yes. Okay, so because we don't have any students in the live class today, what I want you to do now is go ahead and go back to whatever selection you want to read back, whether it be the 60, 80, or 100, or if you want to do all three. Feel free to go back to the one that you want to read back and follow it along with your notes and see how you did. Okay, so that concludes our lower speeds live class. Have a wonderful day.